Hi, everybody. Do we still have Mr. Rivera or Mr. Salt on the phone?
Chris, I'll be right back. I'm going to return a call.
Okay, thank you.
You do, Mr. Schultz here.
Thank you, Mr. Salt. Mr. Cross, Mr. Rivera
And
on
I'm
the
here.
phone. So we're going to get started in just 1 minute. So I'm going to go ahead and gavel us in. Welcome, everybody. It is October 7th, Friday at 3:20 p.m. Sorry for the late start. This is a work session relating to AO 2022-72, an ordinance of the Anchorage Assembly amending Anchorage Municipal Code, Section 3.70.110, to modify the assembly approval process of an arbitrator's decision in collective bargaining for service class A2 and A3 employees for purposes of impasse resolution. So before we get started, we'll go ahead and go around the room. Go ahead and welcome people.
Pete Peterson.
Daniel Voland.
Meg Zalato.
Forrest Dunbar.
Christopher Constant. And on the phone,
Randy Solt.
Felix Rivera.
Kevin Cross.
thank you. And on the administration side, legal department, law department,
Blair Christensen.
thank you. Also, Dean Gates, he's having a conversation in the back. And we do have Ms. Quinn Davidson. She's just stepped out of the room for a moment. Shirley Roughton, our staff, Desiree Camacho, clerk, and we have a member of the public here. So with that, I'm going to hand over the process first to Ms. Zalatil.
Great. Thank you, Mr. Chair. I'm really happy we're having this work session. I asked for it. I've spent a lot of time with this ordinance and really trying to figure out kind of from a base perspective, not only what the ordinance might do, but what's the procedure when we are presented with an arbitrator's decision. I don't believe during my time on the body, coming up on like 3.5, 4 years, that we have had one. And so it's a little bit different than when we have a collective bargaining agreement in front of us. So I would like if we could kind of start with the steps with Ms. Christensen about how an arbitrator's decision comes before the body, and then the steps. And then it's not only whether or not it comes before the body, but then there's like 2 to 3 permutations about whether or not it's accepted or not. And then if it is or isn't, what is the resulting piece to that? I think if we start with kind of just how it comes before the body, it lays a great foundation. Then we can talk about the different approval mechanisms that are before us in the AO and the amendment.
And I would just add, just 1 second. Ms. Christensen, I would add maybe the starting point 1 step before that. So the red meat being the arbitrator's process, but I don't think since I've been on the body some 6 years, we've ever had a kind of work session on how do collective bargaining agreements work. And so I would say maybe even spend a couple minutes before we get to the arbitration and kind of begin at the beginning.
Okay, through the chair to Ms. Alatal. This is Ms. Christensen. So from the beginning, what happens is when we start negotiating with a union, I think the code says 45 to 60 days before we start negotiating, we provide the assembly with notice that we are going to start negotiating. And that generally was supposed to be your opportunity to issue guidance as to that collective bargaining agreement. What this body has traditionally done is issued one resolution that's a guidance for a extended period of time. So you haven't traditionally issued guidance as to a specific bargaining unit that we are bargaining with. But I think that the code anticipates that 45 to 60 day window is the assembly's opportunity to issue its general labor guidance to us that we would then take back and use in negotiating that contract. So that starts our negotiation window. Then we enter into negotiations. And I think our hope is always that we come to an agreed upon collective bargaining agreement with whatever bargaining unit we're bargaining with. And that obviously is generally what happens. And what that means is that the parties sit in a room, we exchange language back and forth, and we slowly enter into what the lingo is TA'd sections. So each section of the contract we go through, and as we agree to it, both parties sign, and then hopefully we end up with a whole agreement that the union then votes on. So before it comes to you, the membership of the union has voted on that and has accepted that as their contract. That contract then comes to you and you vote on the contents of that contract. So that's when we are successful and we come to a negotiated collective bargaining agreement. When we are not successful, which obviously rarely happens.
Hold on there
Mhm.
before you move into that. So I think this is a good time to add the conversation in which be a little more specific. The parties, the administration agrees, labor union agrees by vote, and the assembly's role is to
The assembly's role at that point is to approve it. So you take affirmative action to say, yes, we approve this contract. This is going to be, and then at that moment that the assembly approves it, the parties are bound. This is now our collective bargaining agreement. So we no longer have the authority to negotiate any longer. This is our official contract and both sides are bound by that contract. Okay, any questions on that? When we are unsuccessful at negotiations, the code provides some timelines by which we're supposed to be going to mediation, where we bring in a third party to try to help us mediate the terms that we're unable to agree to. And when then that doesn't work, we go to a two-step arbitration process. The first step is a fact finding, and that's generally to set the general conditions of anchorage and what the conditions under which we're negotiating in. And then the fact finder issues a decision on that. And I think the expectation of the two-step process is that when the parties see that fact finding decision, it might push them to negotiate further, right? Because what normally happens in arbitration is that neither party totally wins, gets exactly what they want. And so it's supposed to bring you back down to reality and force you back to the table. And so we get a fact-finding decision. Then after the fact-finding decision, if we still can't come to an agreement, we go to an arbitration in which our last best offer, management's last best offer, and the union's last best offer are submitted to the arbitrator. And the arbitrator can only pick, there's different subjects, wages, benefits, those types of things. And the arbitrator can only pick either our proposal or the union's proposal. So most arbitrators' decision will be a mix of our wage proposal, their health proposal, our work rule, their work rule, right? And so it's just kind of a mix of the different proposals, but they can't take our wage proposal and their wage proposal and find some, right? Mix that, do something other than either picking this one or picking this one. They have to pick one of the two. And then the decision is issued. And from that point, when the decision's issued, it internal audit costs the arbitrator's decision out. And so just for those of you who aren't familiar with labor, that arbitrator's decision becomes the issues that we couldn't agree on, and then all the issues that we agreed on and we signed together, the two parties, that whole thing becomes a proposed contract. So you have all the terms of the contract together, right? Everything we agreed on before arbitration, and then the stuff we couldn't agree on, all becomes one contract. And that's submitted to you as the arbitrator's decision. And then the converse of that is the municipality's last best offer.
Actually, before we turn to last best offer, if it's okay, Mr. Chair. So what comes when we talk about the arbitrator's decision, because I think this is a salient point, is all the collective bargaining agreement as agreed upon and the arbitrator's decision. And it is brought to us as a package to still approve basically this collective bargaining agreement. It just has, so when we talk about the arbitrator's decision, it's not a standalone arbitration decision. Am I getting that right? Because I think that that's not clear from like the AO we have in front of us.
That is correct. So what the arbitrator's decision really is so because the parties had bargained for a long time before they went to arbitration, the vast majority of the contract will probably have been agreed to. That means work rules, probably, maybe health benefits. I mean, wages are probably the thing that we're arguing over most. I mean, just in my experience, that's most likely what the sticky items are. But I will say that there will be, out of 12 chapters of a collective bargaining agreement that have, 15 sections each. Really, when you're into arbitration, you're talking about maybe 6 sections, not 6 chapters, 6 sections. And so we have agreed on everything but those 6 sections. That the arbitrator rules on those 6 sections, and then everything else that the parties have agreed on comes to you as the arbitrator's decision as the contract to be approved. And that means if you approve it, it becomes the party's contract, right? So it is basically has the legal effect of being exactly the same as the contract you approve when we agree on everything and the union ratifies it and that whole thing. The arbitrator's decision, when it comes before you, has the same effect. It legally is now the party's contract. And so we will be bound by it. The union will be bound by it. It will now be our contract. And I think Dean, I don't know if there's questions. Dean can maybe talk about the procedure. Do you want to talk about procedure?
Yes, so Ms. Christensen asked me to speak about the procedure in terms of how the document comes to the assembly on your agenda, and that process is out. It's laid out in our code in 27090. They're basically, and I guess this is something important to point out, it comes up for introduction first. This is a public hearing item, so it's not just on the consent agenda that gets approved with all the consent agenda items. It comes up and under section 10G for introduction. The code requires a 28-day public comment period before assembly action. So we usually see it introduced at 1 meeting and set for public hearing 2 meetings later, or 28 days at least. I wanted to mention, though, before it's introduced, there's a confidentiality rules. So the assembly members, you give guidance and you get reports how the negotiations going. But there's a restriction on the assembly members communicating to the parties, which is the union or the administration bargaining unit or bargaining team. But once it's introduced in public comment period, you are able to talk to them. That's when that ends. So that 28-day period, yes, Mr. Constant.
That's actually one of my questions I have on my list. At what point does the confidentiality clause invoke? Clearly, you just said it ends when you have it set for public hearing, but when does it begin?
I believe, and Ms. Christensen, correct me if I misstate this, you get a notice when, I guess, prior to when negotiations commence, and there's usually a date, and that's when it begins on that date. So 30, 45 days prior or 60 to when they commence, you get that notice. You're not barred from communications at that time, but the date negotiations commence, when they first sit down to start, that's what that implies.
Okay, so it's not when the 45 days is notified, it's at the end of whatever that date is within the resolution, the specific date. That's helpful. Thank you.
Yeah, and it's communicated by, I think, an AIM from the administration about when they begin. That's correct. And then you've got the 28-day public comment period, and then the meeting where you have the public hearing, and that's where, of course, you take testimony and then debates and decide. And this is, I think, important to note, an up or down vote, and where you can amend the terms of the arbitrator's decision and things like that. So, did I leave anything out, Ms. Christensen? Thank you.
So I think I'll jump in here now. So the ordinance that we proposed in its original format changed a procedure that established a reversal of the standard that we have in the code right now, meaning that the arbitrator's decision would just be accepted by default and would require either a supermajority or a majority vote to overrule the arbitrator. And after much conversation, you have a legal brief, and you have Ms. Alatil and I who wrestled around with this conversation. And I believe for the most part, we've been convinced that the legal department's position is accurate, that we cannot in fact achieve that goal, because what it does is creates a legislative veto, meaning we take away an authority that was granted to the executive to have say in the conversation. And so we have an amendment that is laid on the table as well that would work to change the deal slightly. And instead of requiring a super majority vote to adopt the arbitrator's agreement, it moves to a regular majority vote and then provides the executive with an opportunity to veto that decision. And then, at least in that case, the executive has to put out their rationale, and the public and everyone else can take to task the party that is making the decision to not. And I can imagine a situation where we would have the 8 votes, but what the amendment does is shifts the burden to a simple majority and then allows the executive their say. So that's kind of where we are. And I think if anyone has questions for Ms. Christensen, Mr. Gates about this conversation, about the majority, supermajority legislative veto, this would be the time to ask. Ms. Alatil.
Thanks. So I do have one question. So I agree with the amendment, but just to kind of close the loop on the process, if the collective bargaining agreement and arbitrator's decision comes before the body and it is not approved by, let's say, a majority per this amendment, what happens next?
So what happens next is the code allows the administration to implement its last best offer. It doesn't say you have to. It says you can't. The administration can implement its last best offer. I will tell you, I think that there's 3 different scenarios as to what could happen if the assembly does not approve an arbitrator's decision. I think the most likely thing is that the parties go back to the negotiating table with the arbitrator's decision potentially and start negotiating again to find some middle ground. The second likely, so the 2 other options are that the administration implements its last best offer and the union accepts the last best offer as without objection. And then we're working under the last best offer until we open up negotiations again. And then the third option is that the administration implements its last best offer. The union then has the right to strike. And then obviously, once a union strikes, the entire purpose of that is to get the parties back at the table negotiating again. So I think that there's maybe a misconception that implementing the last best offer is kind of the end of the whole process and that all communications stop. It actually, in my world, it's probably just the beginning of a continuation of the negotiation process or a beginning of a new negotiation process, because some idea that everything ends at that moment, I think, is very unrealistic.
Except when the last best offer is accepted with the union's consent. Does that stop, or do you guys still try to go back?
It's an interesting because I think from the outside world, negotiation looks like this kind of static process where you guys get the notice, we start, we stop, and it seems very black and white. I think that even when we've implemented I don't have a lot of, obviously, I've been with the municipality almost 9 years, and I've been the main labor, up until recently, was the main labor attorney the entire time. And I don't have very much experience with this. And so in my experience, even when we've implemented our last best offer, we've continued to negotiate, because just the threat of a strike a lot of times forces you back to the table. And so I think it is unlikely that the implementation of a last best offer means that we will not continue to negotiate. I think and lawyers always say things in the negative, but to say it in the positive, I think that the implementation of the last best offer is just going to lead to further negotiations the vast majority of the time.
So I have a slight wrinkle to that question.
Okay, yeah, I'm all done. I do have a question about the legal memo when we're ready.
Thanks. And so she asks an interesting question. Let's go to the worst case scenario. We have last best offer, strike, and then some resolution. Does that resolution of the process end up back before the assembly for acceptance of both parties to then we adopt a collective bargaining agreement? Right? Is that the final step in that process too?
Yes, that would be the final step in that process because once we negotiate agreement, if we change the terms of the collective bargaining agreement, if the parties agree to change the terms of the collective bargaining agreement, then the assembly has to approve it as a contract.
And does that get another 45-day letter and then the whole process opens, or what is that process?
No, it's just a continuation, the code contemplates the same process as the original negotiation process. You're still negotiating the same contract. So we would just put it in front of you
Right.
to vote.
That's helpful. Ms. Alatel again?
Thanks. Thank you, Ms. Christensen. This has been really helpful. I think getting the frame on this is great. So at the end of your legal memo, your very last sentence says the proposed ordinance is most likely unconstitutional and should be withdrawn. Could you say whether or not the amendment corrects that and we're good to go with the amendment?
Thank you through the chair to Mrs. Alatel. I apologize for that because there was some haste yesterday to issue. This memo was in a different form previously, and to issue this memo in a form that all the members could read, I issued it quickly yesterday and I should have changed it. The legal department does not see any problems with Mr. Constant's floor amendment. I think legally that would be fine.
Great. Thanks for the clarification.
One more question. So, do you need, no, are you ready to get out of here? Okay.
just surprised by what she just said.
Okay.
Chris's thing totally waters it down, right?
It's a
I mean,
halfway,
no
it's a
wonder
half
they have no
measure.
problem with it.
It's a half measure. So, but it is within the law. So, I mean, it took us a lot of work to really wrap our mind around all the fine points. And I think I have to concede. Sometimes our best ideas aren't legal. So we fix them. But what happens, where does the impasse process in the courts and all of that come into play with the process we're discussing with the A2 and the A3s?
So, Mr. Constant, that's a somewhat complicated question. We only have one union in the A2 now, which is the union that works at the port, 302. And we just completed negotiations with them. And then the rest of the unions would be A3. The idea behind the A3 unions is they could strike for some indefinite period of time without interrupting services. And so we most likely in court would not be able to get an injunction against the A3 unions. And so in that respect, they have a lot more bargaining power, if you will, because they're striking. And so while they're striking, the municipality would have a real impetus to really get that contract done, right? Because we don't have any legal remedies at that point. So we would really be pushed to negotiate with them to get a contract done because we would be, otherwise they would be striking forever.
We kind of resolved that with the plumbers earlier this year. Okay. And 302 is the steam fitter? No, it's the heavy equipment.
It is the heavy
Yeah,
equipment.
operators. Yeah. Okay. So anyone else have questions on this? Anyone on the phone? So this item will be before us on Tuesday, and we'll be asking for your support for the amendment and the passage of the item. Anything else? Hearing none, this meeting has finished early. Have a good Friday and good weekend.
Thanks,